Good afternoon. The time being 12 noon, we're going to go ahead and get started. I realize a few folks are still trickling on. I want to welcome everybody to August's Planning Lunches at Noon webinar, Changes to Planning, Zoning, and Building Code Laws in 2026. My name is Noah Hodgetts, and I'm a principal planner in the Office of Planning and Development at the New Hampshire Department of Business and Economic Affairs. Here's a quick reminder of how to use the Microsoft Teams webinar controls. Please put your questions in the chat and we'll do the best to answer them throughout the webinar. Just a reminder for folks, this is a 90-minute webinar. Hopefully you'll be able to stay with us for the duration, but completely understandable if you have to jump off after 60 minutes. Today's speakers include myself, as well as Michael Hagan, the Building Division Manager for the City of Keene. I'm going to first present about the 2026 planning and zoning statute changes, and then Michael will follow up with the 2025 and 2026 building and fire code changes. So here's the 2026 planning and zoning statute changes and bills I'm going to cover today. So we'll first start with House Bill 244, which is about the transfer of building code and building official references from the planning and zoning statutes to RSA 155A. I'll also talk about House Bill 1010, which makes changes to the multifamily and commercial district law, House Bill 1079, House Bill 1093, House Bill 1103, House Bill 1161, House Bill 1195, House Bill 1246, House Bill 1468, House Bill 1588, Senate Bill 440, Senate Bill 564, and Senate Bill 592. There's certainly other planning adjacent bills that we just don't have time to discuss today. But hopefully this will be a pretty comprehensive review. And if we run long on the presentation or the Q&A, and you have questions about specific bills, please feel free to reach out to Michael or myself. Our contact information is listed at the end of this presentation. All right, so let's get into the thick of it. So the first bill is House Bill 244, updating and recodifying the municipal enforcement of the building and the fire code. You're going to hear about this bill 2 times because it affects both the land use statutes, the planning and zoning statutes, which is what I'm going to discuss now, and it also makes a lot of modifications to the state building code statute, to RSA 155A, which Mike will cover later in the presentation. So it doesn't make any substantive changes to any planning or zoning statutes. It moves all references to local enforcement of the state building code board of appeals, and building officials from the planning and zoning statutes to RSA 155A, which, like I said, is the state building code statute. For land use purposes, building officials and inspectors and building code board of appeals will no longer be considered local land use boards under RSA 673:1, Roman numeral 3 and 5, and RSA 672:7. It also replaces Zoning Board of Adjustments authority in RSA 674:13 to issue building permits when hearing appeals of landowners on a mapped street location on the official map, with the authority to remove the prohibition on a building permit. So instead of the ZBA issuing building permits in these cases, it will be removing the prohibition on the issuance of a building permit. And then finally, the big change it makes on the land use on the planning side is it separates out the power for zoning and code enforcement officers to enforce zoning ordinances and land use regulations, which have remain in RSA 676:15 to 17-B, from the building official's authority to enforce the state building code under RSA 155A:7. It also repeals and moves the following RSAs to 155A. including, as I previously mentioned, sections of 673.1, 673.3, 673.22, 674.34, 52A, 676.11, and 676.13. Those are basically all statutes that have to do with either building code enforcement or issuance of building permits specifically, which you'll now be able to find in different parts of 155A. So House Bill 244 was signed by the governor on July 15th, 2026. It has a stated effective date of July 1st, 2026. House Bill 1010, relative to multifamily residential development on commercially zoned land, is one of two bills making changes to 2025 House Bill 631, which took effect July 1st, 2026. So House Bill 1010 does a number of things. First of all, in RSA 674:80, Roman numeral 1, it clarifies that a municipality shall allow multifamily dwelling units as defined in RSA 674:43, Roman numeral 1, where adequate infrastructure is present on commercially zoned land. So it specifically references the definition of multifamily dwellings in the site plan review statute, which folks may be familiar. 674:43 defines multifamily dwellings as any structure containing three or more dwelling units. So previously, this section of the law did not actually define what multifamily dwellings constituted. It also, in RSA 674:80, Roman numeral 3, expands the reasons that a municipality does not have to allow multifamily dwellings in a commercial zoning district that also permit industrial manufactured uses to include potential effects which may be incompatible from the industrial or commercial use with residential uses. So the additional effects that have been added are dust, glare, and vibration, in addition to what was previously in the statute, air, effects from air, noise, odor, or transportation impacts. Importantly, 674:80, Roman numeral 3, does not require the actual presence of an industrial or manufacturing use in the commercial industrial zoning district. It just requires these industrial or manufactured uses with these potential effects in that district for a municipality, if it so desires to restrict or prohibit multifamily dwelling units in these districts. And then I have another slide on House Bill 1010, but I also want to note here that House Bill 1010 was again signed on July 15th, 2026. So we have a number of these bills with a July 1st effective date that weren't signed until July 15th. And so for all intents and purposes, this bill took effect July 15th. So a few more notes on House Bill 1010, and I realize there's a lot packed into this slide. So RSA 674:80, Roman numeral 1, also adds a lot of clarification in terms of how planning boards should assess where adequate road infrastructure, water infrastructure, and sewage infrastructure is present when evaluating applications for multifamily dwelling units on commercially zoned land. Previously, the statute simply said you need to allow multifamily dwelling units on commercially zoned land if adequate infrastructure, including road, water, and sewage infrastructure, is present, but didn't really define what the test should be for assessing whether these different types of infrastructure were present. So the statute now specifically says that the kind of threshold test for whether road infrastructure is present is whether a traffic impact study shows whether the ability of existing road infrastructure in the vicinity of the project is able to accommodate increased vehicular traffic, the availability of sidewalks and infrastructure to ensure pedestrian safety. For water infrastructure, the statute now says that the water infrastructure, in order to have water infrastructure, applicant needs to receive permission from the owner of a public water system to connect to that system, or in the absence of a public water system, develop a water supply in accordance with RSA 482B. which is the I believe the Water Pollution Control Act that DES enforces, and RSA 485 as applicable. And then the third one here is the test for sewage infrastructure, which requires the applicant to receive permission from the operator of a public sewer within the boundary prescribed by RSA 147:8, or as negotiated between the applicant and operator to connect to the system. Importantly, the statute here says and, not or. So all three types of infrastructure passing A, B, and C here, including the presence of public sewer and the permission of the applicant to connect to the public sewer, need to be available in order to meet the definition of adequate infrastructure. Or the applicant is responsible for installing that infrastructure at their own cost in accordance with state and local regulations. But really the big point here is there is no requirement for the municipality to allow multifamily dwelling units in commercial districts in areas where there's no public sewer. So the water infrastructure, like I said, there's some language in terms of an alternative to public water with the developing other water sources, but you have to have public sewer, and you have to also be able to show that the roadways surrounding the project can accommodate that increase in traffic. RSA 674:80 Roman numeral 2 also clarifies that a planning board may deny an application for multifamily dwellings in a commercial district if the planning board determines that the volume of traffic is not supported by the road design at the conclusion of construction, or the development layout and design do not ensure pedestrian safety. The applicant is unable to secure a source of water, or the owner of an abutting well is able to demonstrate that their well will be unable to meet existing demand, or, and again, this is an or, so the planning board doesn't have to find all three of these conditions exist, just any one of these three, or the applicant is unable to dispose of wastewater and sewage in accordance with required regulations for wastewater disposal. So that was a lot. Again, hopefully that there's some really good, I think there's a lot of really good helpful clarity there. I would say for municipalities thinking about how they're going to go about implementing House Bill 1010, as well as House Bill 1588, which makes other further changes to the multifamily and commercial district law, which we'll get to a little bit later in this presentation. I've seen municipalities try to implement this law in a lot of different ways. I would say the most straightforward way for a municipality to comply with this law, and I want to be very clear, this is not legal advice. These are just kind of from a planning best practice standpoint, what we've seen, what we've observed over the last year, is that municipalities, or several municipalities, have permitted multifamily as a permitted use in their use table in commercial districts where they weren't previously permitted, and then amended their zoning ordinance or site plan regulations. Well, first they've amended their zoning ordinance to note that it's still, the multifamily dwellings still require site plan review, and then some cases they've also, and I would recommend this to communities, to also think about either putting language in your zoning ordinance or amending your site plan regs to actually stipulate, take some of this language in 674:80 and this really kind of clear test for how to define adequate infrastructure for road infrastructure, water infrastructure, and sewage infrastructure. So it's really clear upfront to the applicant kind of what are the criteria for determining adequate infrastructure that they need to be able to provide and document upfront. All right, so we will keep going. Feel free, folks, to put your questions in the chat as we go through. I realize there's a lot of technical information we're presenting, so I'll do the best to try to answer that as we go through. So the next slide, the next bill is House Bill 1079, which is allowing accessory dwelling units to be built within or attached to certain non-conforming structures. This is a further modification or update to the accessory dwelling unit law that took effect July 1st, 2025. So first, this bill removes confusing language from the definition of attached unit and detached unit. In RSA 674-71, Roman numeral 2 and 3. So attached unit now simply means a unit that is within or attached to the principal dwelling unit. Detached unit means a unit that is neither within nor physically connected to the principal dwelling unit. It also clarifies the meaning of RSA 674-72, Roman numeral 6, Roman numeral XI, which states that a municipality requires a municipality to allow ADUs to be converted from existing structures, including but not limited to detached garages, regardless of whether such structures violate current dimensional requirements for setbacks or lot coverage. So that is all that section of the ADU statute said when 2025 House Bill 577 took effect a year ago. So this House Bill 1079 does a couple things. It defines existing structure as a structure existing on or before July 1st, 2025. And then it also clarifies and states that any structure containing an ADU, which was approved and built after July 1st, 2025, when the ADU law took effect, which was still, had to have been approved, would still have to have complied with all the zoning dimensional requirements for the single family home and for the ADU in that district. So when it was approved, and if it met all those zoning dimensional requirements and other zoning requirements, it shall now receive protection from future zoning changes in accordance with 674-39 Roman numeral 2, provided the structure meets the time period for reaching active and substantial development. And now I say 674-39 1A. So that's the 3 years. We think about the vesting statute for site plans and subdivisions vesting, the 3 years to get to active and substantial development, and then the 7 years to get to substantial completion in RSA 674-39 Roman numeral 1. I know there's been a number of confusion here about what the introduction of this language does. I want to be clear that the language here was to only vest the zoning changes. So the vesting protection only applies to zoning and has no effect on any restrictions on how long a building permit for an ADU may be in effect. It simply says, if you get your zoning verification from the town that your ADU meets all the requirements of the zoning, you get your zoning sign off, and you don't go and pull a building permit for whatever reason, you need time, you take your time to get financing, which can definitely take some time due to high costs. You now get the same vesting protections in zoning that larger projects would get. There's also additional language added here that if an existing structure built prior to July 1st, 2025 does not comply with current dimensional requirements for setbacks and lot coverage, a municipality may determine eligibility for placement of an ADU within the existing structure by requiring the applicant for the building permit to demonstrate either that the existing structure qualifies as a pre-existing non-conforming structure in accordance with RSA 674-19, or that the local zoning regulations definition for non-conforming, or it meets the local zoning regulations definition for non-conforming structure and is exempt from applicable dimensional requirements for setbacks and lot coverage. So you either have satisfied the definition of pre-existing non-conforming structure, or the applicant has to show that the existing structure built before July 1st, 2025 received a prior zoning approval or determination from the town that it was exempt from the current dimensional requirements for setbacks and lot coverage. And then the last thing that House Bill 1079 does, it states that an existing structure built before July or existing prior to July 1, 2025, converted to an ADU shall not constitute a change of use under RSA 674-19 or any local zoning regulations, which would cause the existing structure to lose its status as a pre-existing non-conforming structure. So in essence, what this is saying is that you do not, a municipality cannot require a change of use permit for an existing structure built before July 1, 2025 that's converted to an ADU. And 1079 takes effect at the end of this month, so in 11 days on August 31st. All right, now we'll get to a couple of these bills, which should go, are a little bit less meaty. So House Bill 1093 relative to public charter schools and governmental land use exemptions. So House Bill 1093 amends RSA 194B:3, Roman numeral 1A, to require charter schools to have the same rights as public schools, including treatment as a governmental land use under RSA 674:54. And it amends RSA 674:54, which is the governmental land use statute, sections Roman numerals 1 and 2, to provide charter schools the same exemptions from having to comply with local zoning as other governmental land uses. And here's a picture. So this is a charter school. This is Founders Academy down in Manchester. All right. So I do see a couple questions popping in the chat here. One is about 1010 and density requirements and gross acreage. That's going to come back, and we'll talk about that in a minute when we get to 1588. The second question is about, and my apology, I'm looking over at a separate screen for the question, is about the ADU statute 674:72 Roman numeral XI. If a structure is unfinished and a municipality has an ordinance about expanding a non-conforming structure by increasing the area volume by means of finishing an unfinished space, heating and insulating, but does not further encroach in setbacks, can a municipality still enforce their expansion of a non-conforming structure ordinance, or is that bypassed per the new laws? Great question. So I would say if the non-conforming structure is increased in size, is altered so as to substantially increase the non-conformity, that is a different situation that the statute does not address or contemplate, except for building into the setback, except for that exemption from application of setback and lot coverage standards. But your question is really about you're increasing the finished space of the unfinished structure. You haven't encroached in the setbacks. I would say that this statute, the legislative intent of the statute, is very much to allow for the conversion of those structures into ADUs. So if you have, if your ordinance has language prohibiting those non-conforming structures from being finished, yes, this law would bypass that. Correct. House Bill 1103, allowing municipalities to utilize a community revitalization tax relief credit on a wide variety of properties and uses. So for folks not familiar, as this graph shows, RSA 79E, generally speaking, freezes the increase in tax assessment resulting from substantial rehab of a building or new construction for a set amount of time. And if you want to take a deeper dive into RSA 79E, we're going to do our whole entire plan webinar next month on Thursday, September 17th at noon, all about 79E and the different types of 79E a municipality may adopt. But for today's purposes, all you need to know about House Bill 1103 is that it amends RSA 79E 4D to give municipalities the option of using RSA 79E for conversion of buildings and spaces being used for commercial or industrial use to residential use, in addition to allowing for use of 79E for conversion of underutilized office spaces to residential use. It also amends 79E:4-C to allow for 79E tax relief for construction of new housing units for up to 7 years if there's no workforce housing created, or up to 15 years if workforce housing is created. Importantly, the municipality may impose affordability requirements for units and housing opportunity zones seeking 79E tax relief, but they are no longer required. The statute previously required, I believe it was a third of the units to be affordable, which the affordability requirement has been completely removed. And it's also clarified tax relief can explicitly apply, 79E tax relief can apply for new construction of housing units. And the new construction, the tax relief period for the new construction of housing units under 79E4C, the statute states shall begin upon issuance of the certificate of occupancy of the CO or completion of construction of the new housing units. And then just a quick clarification here, the local legislative body would need to vote to adopt each new section of 79E separately in accordance with the procedures in RSA 79E:3, even if the municipality already has adopted traditional 79E and has other 79E districts in the town. And that House Bill 1103 also takes effect at the end of this month on August 31st. All right, moving along here, House Bill 1161. Removing the requirement for municipalities to have an advisory board for development districts. This simply, in the tax increment finance statute, RSA 162K:14, Roman numeral 1, makes the creation of an advisory board for overseeing each TIF financing or TIF development district an optional requirement rather than mandatory. Previously, the legislative body was required to create an advisory board for each TIF district. And that 1161 took effect July 21st. House Bill 1195, relative to municipal zoning requirements for child daycare providers. So House Bill 1195 builds off of House Bill from 2 years ago. This bill number is escaping me. But it amends RSA 674:16, Roman numeral 6, to require family and group child cares for up to 12 children to be allowed by right as an accessory use in the primary structure. And then there's also this new language which says, or existing accessory structure on lots where residential uses are permitted if the family child care complies with DHHS childcare licensing requirements, which can be found in HEC 4002. So previously, the 674:16 Roman numeral 6 simply gave municipalities the option of allowing family and group family child care by right or conditional use permit. So this takes away the ability of municipality to allow family child care via CUP. And it also adds this option, or I shouldn't say option, adds a requirement that family and group family child care also be allowed in existing accessory structures. So they don't have to necessarily, municipality doesn't only have to allow them in the primary residential structure, but also has to allow them in an existing accessory structure. Not a new accessory structure, but an existing accessory structure. 1195 also continues to exempt family and group family child care from being subject to local site plan review in any zone where a residential use is permitted. And then it adds a new section about zoning of child care centers. So RSA 674:81 states that group child daycare centers, including child care centers, including group child day centers, infant and toddler programs, night care programs, preschool programs, school age programs, and small group child daycare centers. These all have different definitions in RSA 170E Roman numeral 4 IV C to I, that child daycare centers need to be allowed by right on commercially zoned land as the center complies with DHHS childcare licensing regulations. So again, it mimics that language where the childcare center has to be allowed by right if it's in compliance with DHHS childcare licensing regulations. It also has to be allowed by right on commercial or industrial zone land if there is a child care center or prospective child care center to be located in that commercial industrial zone that's going to be for the exclusive use of employees of a business located in that zone. So kind of thinking back to the multifamily commercial district statute where there's that carve out for commercial industrial districts. There is a carve out, so municipalities don't have to allow child care centers in commercial industrial districts unless the child care center is going to be for the exclusive use of a business located in that commercial industrial district. And then finally, 1195, and this is significant, exempts all child care centers that are going to have a licensed capacity of 30 or fewer children from site plan review. So you can continue, you know, they're still going to have to go through all the licensing requirements. The licensing requirements still do have requirements in terms of for diapering and diaper disposal and wastewater. You can still subject your building code requirements and life safety requirements, and the licensing, the DHS licensing requirements require that. They have, it's very still requires sign off by the zoning official, that the health officer and the local fire inspector or fire chief, that you're meeting the health regulations and you're meeting the life safety codes. But you cannot subject child care centers going forward from July 1st, so now in effect, to site plan review if the proposed child care center is going to have a licensed capacity of 30 or fewer children. Hopefully that makes sense. And thank you. Somebody pointed out that Heather, my colleague, pointed out that the previous child care zoning bill was 2024 House Bill 1567 that this builds off of. All right, next bill relative to planning boards serving on other local boards. So House Bill 1246 mirrors 2025 House Bill 92, which required a member sitting on a planning board and ZBA to recuse themselves from voting on matters in their capacity as a ZBA member previously decided by or pending before the planning board. So it specifically amends RSA 673:7, Roman numeral 1, for planning board members also serving on a ZBA. So it states that planning boards who also serve on a ZBA shall recuse themselves from voting on any matter previously decided by that board in a quasi-judicial capacity in which the member participated as a voting member. So you can't vote if you're on a planning board and a zoning board now, and this was true a year ago when from the ZBA side. Now it's applicable on the planning board side. You have to choose if you're on both boards. You can only vote on an application once on one board. You can't vote on both. And this bill took effect June 21st. House Bill 1468, relative to flood resilience section in a municipal master plan, amends RSA 674:2, Roman numeral 3, by adding a flood resilience section to the list of optional master plan chapters a planning board may adopt. The flood resilience section is in addition to the existing optional natural hazards and coastal management sections, which also reference flooding, which a municipality planning board may adopt in their master plan. I'm not, for the sake of time, going to read right now the definition of what a flood resilience section is in 674:2(3)Q, but we will distribute these slides afterwards. There's links, and you can take the time to read this definition. And again, that goes for all this text. So now we get to the other multifamily and commercial district bill, House Bill 1588, which folks may have heard about. I know there was a question up there, which I'll get to in a second. So House Bill 1588 is relative to the regulation of accessory parking for vehicles by local legislative bodies and multifamily housing within commercial districts by municipalities, establishing a special assessment district. This bill was originally never about multifamily and commercial districts. This was about establishing special assessment districts. When it went over to the Senate and then went through the committee of conference process, there are a lot of additional language got added in modifying the multifamily and commercial district statute. So the first thing that 1588 does is it amends 674:16, Roman numeral VII, to prohibit municipalities from requiring one residential parking space per unit to be garaged. So folks may recall the parking space requirement from a year ago that says municipality can't require more than one parking space per residential unit. This now states that that space, municipality cannot require that space to be in a garage or garaged. 1588 also amends RSA 674:80, Roman numeral V, to clarify that multifamily dwelling units shall be allowed as a matter of right in commercial zoning districts. So before it just said something to the effect of municipalities shall allow multifamily districts in commercial zoning districts. It didn't say as a matter of right. There was, well, I don't think the legislative intent originally was ever to give the municipality an option to allow multifamily and commercial districts via CUP or special exception. That authority has been removed, and municipalities are now required to allow multifamily dwelling units as a matter of right in commercial zoning districts, again, with the stipulation that adequate infrastructure is present. It also amends 674:80 Roman numeral V to clarify that a municipality may subject applications for multifamily dwellings in commercial zoning districts to site plan review. So municipality planning board's authorities subject multifamily developments in a commercial zoning district, like in any other zoning district, to site plan review continues, and that has not been altered. However, it also very significantly adds new language, also adds language to 674:80 Roman numeral V to limit the type of regulation of multifamily dwelling units in commercial districts existing, created, or expanded after July 1st, 2026, which is when the original commercial multifamily commercial district statute took effect. So the only type of regulations municipalities may impose on multifamily dwellings and enforce are frontage, setback, and height requirements, provided that such requirements shall not differ from what is allowed for commercial development. Let me say that again. Municipality may only impose frontage, setback, and height requirements for multifamily dwellings where there's adequate infrastructure present in commercial districts. So while it's very clear that municipal zoning regulations are clearly limited to frontage, setbacks, and height requirements, the law does not really, it's silent on whether what a planning board may or may not regulate using its site plan review powers, as RSA 674:43-44 site plan review statute was not amended. But I encourage communities to tread really carefully, because the drafters of this law also added, if you'll see in bold italics at the bottom of this slide, a provision in Roman numeral 7 of 674:80 that requires reimbursement of reasonable attorney fees to the owner of commercially zoned land if the owner brings suit and is improperly denied an application for multifamily dwelling, or if the owner was subjected to requirements not allowed under the statute, i.e. regulations that go beyond frontage, setbacks, and height. So they built in this liability kind of clause, and the municipality could be on the hook for attorney fees if the applicant is denied, and is denied because the municipality has tried to subject regulation requirements beyond those allowed in this section. So we'll have more guidance coming out on this when we put together our guidance document this fall, but I don't want to overstate, or really want folks to be aware of that. And then there's two other things that 1588 does. It states that enforcement of applicable state fire, building, and other requirements under RSA 153, RSA 155A, and RSA 45A remains allowed. And it also adds 674:80 VI and states that a municipality shall allow pre-existing non-conforming structures to be converted to multifamily dwelling units or mixed use, provided that the structure's envelope is not altered to further violate zoning district dimensional requirements. So whereas the first House Bill 1010 took effect July 1st in concert with the signing, and I believe I think I said July 15th is when it got signed, in concert with when the original multifamily and commercial district statute took effect, this House Bill 1588, further modifying on the multifamily and commercial district statute 674:80, does not take effect until mid-September. So you have a few more weeks, September 13th, 2026. There's also one other section in 1588 which creates a new section about special assessment districts for infrastructure, creates a new RSA 162V. We don't have time to address that today. All I'll say is that this new statute closely mirrors the already existing authority to create special assessment districts for infrastructure that can be found in RSA 150 in RSA 52A. So I have one or two more slides, I believe, on the 3 Senate bills, and then I'm going to turn it over to Mike to talk about the building code law changes. So Senate Bill 440, relative to the adoption of energy efficient and clean energy districts by municipalities. So it amends. So this is the statute which enables municipalities to adopt commercial property assessment and clean energy. Commercial property assess clean energy and resiliency districts based on legislation that reorganized 53F last year. It clarifies that unorganized, unincorporated places, primarily in North Country, may adopt CPACER districts, and then more importantly, provides the option for the governing body in a non-charter town or village district to adopt CPACER and establish a CPACER district in a municipality instead of the question on adoption of a CPACER district being required to be voted on by the legislative body at town meeting. But if the governing body is going to avail itself of this option, the governing body must hold at least one public hearing prior to voting on adoption and notice the public hearing according with RSA 53F Roman numeral 2. And there's also some language in here saying that for these non-charter towns, the municipality may vote, so the legislative body may vote to prohibit to prohibit the establishment of CPACER districts or dissolve any existing districts. I don't have time to go and explain CPACER and how it works. It's a really interesting program for thinking about how to decouple energy costs for commercial development, especially residential, for both commercial and commercial industrial development, and kind of an alternative financing mechanism that the Business Finance Authority is helping to administer. BFA has a great website. I've put the link to that in these slides. Again, these links will be, you'll be able to click on these links and go through those hyperlinks when we distribute the slides after today's webinar. So I think I have down to the last two here. Senate Bill 564, prohibiting certain municipal development restrictions. The Senate Bill 564 doesn't take effect until April 1st, 2027. So you do have some time. This is I think one of the only bills where municipalities do have some time to go through it. So it creates RSA 674-21-B, which does really three different things. It prohibits municipalities from limiting road length if the road complies with the state fire code. It removes the ability for municipalities to cap the number of housing units on dead-end roads and streets unless such cap is in compliance with the state fire code and NFPA standard 1141. I'm not an expert in NFPA standards by any means, but generally speaking, as it was talked about during the hearing process, NFPA standard 1141 only requires one fire apparatus access route for roads with developments of less than 100 units. And for roads with developments of 100 to 600 units, requires 2 access routes. It also, and this is where there's some really interesting language. It also requires municipalities to permit the placement of utilities defined as including septic systems, wells, electric distribution, drainage structures, stormwater management structures, and other utilities with or along any designated buffer area, including but not limited to perimeter buffers, residential buffers, setbacks, and open space areas of a subdivision or lot. However, it doesn't, so you have to allow utilities generally in buffer areas and in open space areas of a subdivision or lot. It doesn't require placement of utilities in wetlands as defined in 482A2. So if they're a prime wetland, or if they are protected shoreland defined in RSA 483B 4, Roman numeral XV. But then it does also state that section 4 of 674-21B also states that the municipality has to permit utilities by a conditional use permit or special exception if the utility is going to be located within or along wetland buffers or conservation areas of a subdivision or a lot. So this language, in some ways, is a direct contradiction. On one hand, it says that if it's a conservation, if it's a open space area of a subdivision or a lot, you have to allow it. But if it's a conservation area of a subdivision or lot, you have to subject it, you can subject it or have to subject it to a conditional use permit or special exception. I don't know very many municipalities that make a distinction in their conservation or open space or cluster ordinances between a conservation area and an open space area. I would say here that if your zoning ordinance or subdivision regs currently refer to open space areas of subdivisions or lots, you might want to consider changing this terminology to conservation area to retain the option to issue a conditional use permit or special exception for placement of utilities in these areas. Hopefully that makes sense. And you do have some time for that. Like I said, this doesn't take effect until April 1st of 2027. And then finally, just going ahead of my slides here, 674 21B, Roman numeral 5, also had some very interesting language, which again, this is not legal advice, but adds a retroactive requirement that municipalities shall not impose additional restrictions or requirements regarding building or lot sizes for affected properties. So affected properties by this statute before the effective date of April 1st, 2027. I think the legislative intent here was that they didn't want municipalities creating other requirements that would make development on buffers impossible and try to circumvent this law. The issue is that the law doesn't take effect until April 1st, 27. And generally, per the state constitution, laws cannot be retroactively applicable. So I don't know what's going to happen, how this language is going to get interpreted. I suspect it will be challenged in court, and we'll have to see what the courts say on that one. Finally, RSA 674-21B, Roman numeral 6 states, nothing in this section shall be construed to otherwise limit the authority of municipalities to enforce generally applicable house safety, environment, or building standards, to conduct planning board and conservation commission review, or to impose reasonable conditions necessary to ensure compliance with the state fire code. Or RSA 483B, that's the DES wastewater standards. All right, last bill for me is Senate Bill 592. This is a quick one, enabling regional conservation energy resource planning for habitat strongholds and wildlife corridors, and creating a commission to study transferring ownership of the Winnipesaukee River Basin. So this adds responsibilities for habitat stronghold and wildlife corridor planning to the Regional Planning Commission's responsibilities in RSA 36:45 and RSA 36:47. It amends RSA 36A2 to require municipal conservation commissions to include an inventory of habitat strongholds and wildlife corridors in their natural resource inventories. So that's their NRI. And then it adds some interesting language that says in the Conservation Commission statute, though, not in any of the planning and zoning statutes, that the inventory of habitat of strongholds and wildlife corridors in an NRI shall not be utilized as the basis for municipal zoning or planning purposes. The intent here was to try to, I think, prohibit creation of zoning or zoning based on protection of wildlife corridors and habitat strongholds. There's no modification of the zoning statutes to take away that authority that is specific to the Conservation Commission statute. So again, not legal advice, but the planning and zoning statutes have not removed the authority to create zoning to protect wildlife corridors and habitat strongholds. There's also a commission to study transferring ownership of the Winnipesaukee River Basin. That's a sewer system up in the Lakes region from DES, as currently owns it, to potentially to a third party. And most of this bill takes effect September 13th. I do, for the sake of time, want to turn it over to Mike. But I'm going to go through like two of these questions. So I had a question earlier. Let me just move over my screen. Under House Bill 1020, I don't see any density calculations based on a gross acreage basis in the commercial zoning district. Does anyone have examples that allow for multifamily in excess of 5 dwelling units per gross acre in their commercial district? So as I said, 1010 doesn't touch that, but 1588 very much does address that. And you cannot prescribe a set density for multifamily and commercial districts per House Bill 1588. So a gross acreage per number of units per gross acre is not a permitted regulation under House Bill 1588. Question from Donna: if our zoning does not allow childcare centers in a residential district, does new law require that we now allow them in a residential zone or only in a commercial zone? So, and then that section is confusing. So the family and the in-home childcare is required in residential districts. The childcare centers are not required in residential districts. Childcare centers are only required in commercial districts. And then final question from Ben: how does House Bill 1010 and House Bill 1588 affect an application already under review by the planning board? We have a multifamily project currently being heard. So 1010 is in effect today. That's undisputable. Most of that is really clarifying language that should hopefully help the planning board evaluate whether there is adequate infrastructure present. And when you're undertaking the site plan review process, I don't think there's really a lot of, I think that should hopefully help you evaluate, and I would say definitely applies to project already under review. For 1588 that hasn't taken effect yet, I would say if there's an approval prior to September 13th, which I think is when I said 1588 takes effect, then absolutely. Or the approval before September 13th, then 1588 doesn't apply. If the project is still pending, then the requirements of 1588 will certainly kick in. And I would say if the municipality tried to impose requirements beyond the frontage setback and height requirements, the applicant could potentially appeal any denial based on those regulations. We have a couple more questions that are coming in. We'll come back to these, but I really want to get to Mike on the building code stuff. So go for it, Mike. You can take control.
Thanks, Noah. Yeah, Noah, that was a great presentation, and I'm sure you have a bunch more questions. So I'm going to keep this brief. I'm going to try and fly through the objective here. I'm not an attorney. Really, I'm just trying to get information out so that people are aware of a lot of the changes that have happened over 2025 and 2026. The reason why I'm including the 2025 is it's easy to forget the bills that were so many bills last year, and then all the bills are coming that came this year. So I'm including a few of them that overlap, and you'll see that throughout the presentation. So I'm just going to take control of this. Great. All right, so a lot of changes have taken place as far as the where you're going to find information. Not necessarily all the changes have taken place of the actual wording of it. It just replaces it and puts it into RSA 155, where a lot of the building code requirements have been generated since 2003 or 2001, 2003. I can't remember exactly. That took into effect, that actually adopted a state building code. So they're trying to navigate all of the stuff that was in all the 670 series into put them all into RSA 155A. So a lot of changes. The 25 plus years that I've been with the city of Keene, it's definitely changed the way a lot of these bills what you'll see is it changed the way that you normally have done business in the past. So big changes. So just kind of go through this. These are the bills I'm going to cover, and I promise I won't. I'm just going to highlight them, give you some advice on what you should do. Not legal advice, but just some advice to look at your ordinances that may be affected by some of these bills. So 188 was passed last year for. It was signed on July 15th, 2025 took effect in July 1st of 2026. So I'm not gonna. These are the bills I'm gonna cover with you. There's a couple of honorable mentions at the end that will probably pop back up at this coming year. So I just want to mention them. They are in interim studies. So again, 188, Senate Bill 188 was July of 2025. In July 1st of this year, all of the other bills took effect, except for a portion of SB 494, which is the fire code that took effect July 27th of 2026. But another portion of that bill doesn't take effect until July 1st of 2027. Now I'm going to go through some of these. So why I mentioned SB 188? A lot of communities have been asking me. We did some collaborative effort between NHMA, the Building Code Review Board, New Hampshire Building Officials Association, to come up with a document that really explains what third-party plan review and inspections entail. We did put together a collaborative checklist that communities could use for reviewing and approving third-party plan reviews. It puts restraints on communities if the developer chooses to use a third-party plan review, there are certain timeframes that the municipality will have to adhere to if it is an approved agency, and there's a list for that. I'm not going to go into too much detail with that because we don't have an additional hour to go over it, but qualifications are required. Again, it's under RSA as well as the BCRB amendment. One of the big changes to the state building code this year is it removed all of the chapter 1s and consolidated them into one state of New Hampshire chapter 1. So when enforcing the code, you have to refer to the BCRB website, which is hosted under the State Fire Marshal's office, to have that chapter 1, the state of New Hampshire chapter 1, that covers and references all these RSA changes and goes from there. So take a look at that collaborative document between NHMA and New Hampshire Building Officials Association. It does a great checklist. It goes over what the responsibility of the applicant is, what can constitute an approved third-party agency, what the responsibilities are of the municipality. So it's a good checklist. Really, oversight. One of the big things for municipalities is the 40% redoing your fee schedule to recognize the state law requirement that if they utilize a third-party plan review or inspectors, there is a discount to the fee. So you should look at your fee schedules, go over that, which will later on in this kind of build onto the rest of what I'm going to talk about in 428 and 244 and SB 94. So these are heavily intertwined, HB 428, SB 94, and 244. A lot of them, it overlaps. So HB 248 was the first one to be adopted in 2025. 244 was initially started in 2025. However, it didn't get adopted because there was too much intertwined, and as Noah explained earlier, I wasn't going to list all the sections that goes into, but there's about 13 different places in the 670X series that pulled information from that 670 series and brought it into RSA 155. And some additional clarification and wording on that. So they're very intertwined. So I'm going to kind of break them out and break them down a little bit. HB 248 again was adopted last year, but it didn't go into effect until this year. So July 1st of this year it went into effect. It changes a lot of the authority and enforcement provisions that are in RSA 4722 and 67451. So basically taking that enforcement sections out of that and putting it into 155. There's also another bill that I didn't put on here, but it's SB 438, which kind of ties into the 67451 section about confirmation requirements for ordinances. But we're going to get into that a little bit heavier here on the next few slides. So basically, one of the key things on this is it made New Hampshire a one code state. It did allow for more stringent municipal amendments to certain sections of the code. It couldn't be blanket code. It took away the ability to adopt separate codes from the state or from the municipality and put it to the state, so that when you build in Keene or you build in Nashua, you're using the same standards other than the environmental standards, higher snow loads if you're building up north, or lower snow loads if you're building here, or higher wind loads if you're building on the seacoast. So it prohibited amendments that were less stringent than the state building code. However, you could have adopted more stringent. When we get into the next key changes on the next bill, you'll see that under SB 94, it completely takes away the ability to make any technical amendments, and only administrative amendments can be made to the state building code now. So the other key section of this, I'm kind of jumping ahead of myself, is the enforcement, local enforcement, and the requirements for where you find that authority now. An effective date was July 1, 2026, even though it was a 2025 bill. Kind of went over those sections. I'm going to hop through so that we can have a little bit of time left to answer questions. 244. This was again, a 2025 bill that had broad-reaching effects on all of building code, bringing things from, again, 670, the 670 series into the RSA 155A sections. So it's an 11 or 12-page bill that basically picked through everywhere where you saw either building inspector, code enforcement officer, anything that referenced that in those old sections got brought into, if it came with any authority, got brought into 155. So it was a really big change. It also picked up this legislative cycle, even though it was introduced in 2025. It finished out in the 2026 session. It took away the Board of Appeals, which Noah touched on. If you already have a separate building code review Board of Appeals set up, in most cities, I believe Nashua has one, Keene has one, Manchester has one, separate from the ZBA, those can still remain. However, if someone is aggrieved by the building official's decision, though, those appeals now go to the Building Code Review Board, which we've seen a big uptick in that for board appeals at the state level. Municipal enforcement clarification, and then administrative statutes memorialized in different sections. Again, one of these big changes was enforcement shall comply with the state building code without further local modification. This was hands down took away or handcuffed the communities to only have one state code. And as a building official, I couldn't disagree with this, because you would go to a different community and they would say something completely different or have a different requirement. Why do you require a permit in this location and not in this location? It's easier to train inspectors. It's easier to train building officials when you have one state code and one clear path for training purposes. So it was a really good change in some ways, but it did limit, which doesn't prohibit municipalities from going to the State Building Code Review Board and making an amendment that works for the whole state of New Hampshire, not for just one community. So if you have that sort of thing that worked in your community that is no longer valid, certainly you can bring it up to the state level and have that amendment put into the state building code. So another big change was the appeals that I was talking about, inconsistencies. Again, I went over the existing local boards can exist if they were separate building code review boards, not part of the ZBA. There was a no, and now with the new change, it will come up where you can only appeal to the local board for local amendments, meaning that if there was one that was in effect prior to 2025, then you would have the ability to bring that to the local building code review board for the appeal process. Hope I'm not confusing too much. It's hard to read a crowd when you can't see anybody's faces, but if you have questions or comments, feel free. Again, we have our information at the end. I can go in more in depth on that and the process for that. Certainly good resources is the Building Code Review Board, the New Hampshire Building Officials Association, and the State Fire Marshal's Office for a lot of that clarification as well. So a lot of the big highlights, clarification, they instead of having different names meaning the same thing, the biggest change was changing building inspector to building official, changing building, there was a bunch of different names. I think there was 3 or 4 different terms in different sections in the 670X series, and actually making it uniform throughout that process. There was a question that came up. The ZBA continued to serve as the appeal board for the building code issues. As of July 1, they no longer serve as the Building Code Review Board Board of Appeals. Under the new requirements, the ZBA would no longer be hearing those. Great. All right. Clicked ahead here. Permit authority. A lot of the retention on the fees that you charge, the process in the way that you process permits can all be adopted locally through your local ordinance. The enforcement authority remains the same, but it's pretty clear that you want to make sure that who has, or that the building official is lifting and making sure that they're looking at the ordinance and making the changes that need to be put into the ordinances that may already exist. So a lot of these sections that were in your ordinances, I can't stress enough that you go back and reference the right sections. Your enforcement authority location has changed. So when you're citing for building code violations, that you're going to need to update those ordinances in order to reference the right enforcement sections for that. Again, we talked about the appeal or the repealing of municipal amendments to technical requirements. Again, you still retain the authority to have your ability to do the enforcement. However, no technical amendments can take place at the local level anymore, and that was a big change. Unless it pre-existed, unless it was confirmed and pre-existed to July 1st of 2025. So now I'm on to SB 94, and this is where it overlapped with a lot of the other RSAs, and basically took the authority, complete authority for any amendments, any local amendments, and change the sections where adopting those ordinances. I can't stress enough that when you make these changes, you have to send your ordinance to the Building Code Review Board for confirmation. They post these on the state website so that all the ordinances are available on the State Building Code Review Board website. So there's a question that came in. If someone wants to appeal a building permit issued by the building inspector, can they go to the ZBA as an administrative appeal? That is a great question. And again, I'm not your attorney, so I would consult with your local attorney. According to the new changes, looks like Noah already answered that question. So if you want to read that, and I'll just continue for. Yep.
I was answering an old question. Sorry.
Oh, an old question. Okay. All right. Sorry about that. I was like, wow, that was quick response. So, according to what I read, the zoning board could not hear any appeals in regards to the building code issues. It's not they don't have the authority anymore. It was taken out of that RSA and put into 155A, where the ZBA no longer has authority over that. Now, if you already had an established building code review board, separate from the ZBA, those can remain. Which mostly, I think only cities had those. So just again, check with your local attorney, but that's the way I understand the statute reads at this time. Now, if it's in regards to planning or zoning requirements for issuing a building permit, that's a totally different issue. So I just want to clarify that. If they're not meeting zoning requirements, so a permit can't be issued, if that makes sense, or maybe I'm confusing the issue. But no technical amendments. I'm going to try and fly through this so that we have about 15 minutes left. SB 94, again, review existing. This is some stuff to go back to, bring back to your team and your community, that review your existing ordinances for outdated technical amendments. You may have something in there that says, you cannot be able to shed more than 120 square feet. That is a technical amendment to the state building code, where the state building code for residential allows a shed up to 200 square feet to be built without a permit. So restricting it more, that those technical amendments are no longer valid, unless, and again, there's that caveat, unless they were adopted and confirmed prior to July 1st of 2025. Verify existing administrative amendments, also update references, coordinate with legal counsel. Obviously, I'm not an attorney. I'm just giving you some advice and helping you get through the process of how this has changed and what you should be looking at in your building code ordinances, and where some references are. All right, HB 1159. This is an easy one. It's basically taking the building codes, the 2021 building codes, to the 2024. Ones that remain the same are the IECC, which is the International Energy Conservation Code, and the NEC, which is the National Electric Code. So those remain the same. There was some amendments that went along with those. So take a look at those. Again, all amendments to the state building code can be found at the BCRB website, hosted by the State Fire Marshal's Office. If you just Google State BCRB, it has all the technical information, as well as a courtesy document that gives all of the information for the amendments for the state of New Hampshire. So RSA updates, adopted new code additions, maintain 6-month concurrency. So right now, as of July 1, the 2024 codes are all in effect. However, a contractor could choose to still build under the 2021 codes. So until January 1st, or until December 31st of this year, they can choose to build under the old code requirements. So they could submit a brand new project. It doesn't have to be a project in the works. It could be someone is just familiar with their requirements for the 2021, and they want to build under that under those requirements, they can certainly apply for their permit, but they have to identify that they're using the 2021 codes as part of that requirement and scope that on the plans, and they can continue to build under the 2021 until December 31st of this year. After January 1st of in 2027, all buildings will be built under the current requirement of or under the 2024 code requirements and these updated with amendments. All right, big one. HB 1681, innovative housing structures, tiny homes, tiny houses, tiny homes on wheels, FOWs, and yurts. This was a pretty big. There was a lot of collaboration on this bill, and it still leaves a lot of questions up in the air. Again, one of the things we fought for, I should say, the group that was working on this was, at first the bill read that you shall allow for innovative housing structures like tiny houses on wheels, and yurts. So this was a bill that took a lot of back and forth with a lot of different groups to get it to where it is, so that it says that you may allow for these types of innovative housing structures in your community. With that comes some requirements. Look ahead here. So the key language is basically it creates the construction and inspection. I won't get into the zoning and how you do all of that stuff. If you have questions on that, I'm sure Noah and his group can help you with that. I'm just going to concentrate on, if you see one of these structures or you want one of these structures in your community, the resources that you have for helping you through these processes and verifying these requirements. So basically what this bill did, they didn't want to consider these to be part of the modular program because they're not built in factories. They're innovative. They're separate types of structures that are unique to building code requirements. So essentially, what the idea behind this was, a tiny house has to be built on a foundation, right? That's already in state law. We worked on that back in with the 2018 code update or 2015 code update. We allowed for tiny homes to be built. At the time, it was only up to 400 square feet. Now the tiny homes can be up to 600 square feet through Appendix Q at the time, through the state or through the residential code and the state building code. So it gives you some exceptions to that, and how you would allow for tiny homes to be built, not meeting a standard home building requirements, and having sleeping lofts, and having not requiring stairs, but a ladder situation getting up to a sleeping loft, and working with the fire code on making sure that it collaborated with those two changes in regards to egress windows on that in that loft area, and some other requirements with that. So basically what this bill did is it allows for the Building Code Review Board to evaluate these and actually create an amendment. We weren't sure at the time, because the way the Building Code Review Board works is, when amendments come through, they have to be ratified by the legislature. So we attach it to a yearly bill that gets put in October and get introduced in November. So you get the language with it, with all of the amendments, but it doesn't go through until the end of May, June, July, when it gets through all the sausage. So this bill allowed us to actually make those amendments without having to go back to the legislature. So the Building Code Review Board look for some updated requirements on these types of structures and how they'll be regulated. The other thing it did is it allowed for some of these structures to be built in other areas and then transported here with a local building inspector in that area certifying that this meets the minimum state standards, either to the state building code or to the state modular program. So It will get really interesting. I hope to see some of these. One of the big aspects of this is how to connect. The State Fire Marshal's Office will provide um, really good assistance with this because they already have a modular program. They're already working on a bulletin to say what's required as part of the permitting process. So when you have a site, when you're going to put one of these in your backyard, it can't just be hooked up with a plug, right? It needs an actual pedestal, a permanent power source, if that's what it's going to be used for. So similar to the requirements that you'll see in, or regulations that you'll see in a mobile home park, where it has a pedestal, it has water and sewer hookup, it has certain requirements that have to be met as part of allowing for these types of structures. So consider that when you're making your amendments or allowing for these types of structures in your community, that they have to have certain, that these site requirements can be put into that planning process or that review process prior to then just issuing a building permit, because there other boards may want some say on that. Hopefully that's helpful. I think that these can be a good opportunity for some temporary housing and meeting that that need for that New Hampshire has for housing. Moving on to the next one. I know we're getting low on time here, so I'm gonna fly through these. I would certainly, if you speak to your fire department, speak to the state fire marshal's office. They have some a lot better clarity on these. I'm just bringing this up. One of the big things in 155 was clarification on the authority, appeals, alternative materials, code modifications, and statewide consistency. So basically on July 1st of 2027, the state fire marshal, I believe I have this on the next slide, the state fire marshal will be able to issue clarification and modification um, uh, to building code requirements. So if your building official is not sure about something or uh, isn't able to provide clarity or clarification on a potential alternative design or material, they can actually refer to the state fire marshal's office and they'll write a, a decision, de novo decision that is binding and that can be appealed. The appeal process would be you can appeal it to the Building Code Review Board, and then after that, local court. So really, it changes how this appeal process or alternative design and materials. There's actually someone that you can go to or an entity that you can go to help if you're not familiar with. The ICC codes did a really good job this year of giving better clarification on what is an alternative material, or how can you use this to still meet the code requirements, like building up of a fire separation, or maybe there's a new product that you're not familiar with or that hasn't gone through the ESRI process or the evaluation services process. However, the marshal's office may be familiar with it, or may be able to use reference documents at the national level. So alternative means and method. Again, I know we're running low on time, so I want to leave enough time at the end for questions and comments. But this goes into effect July 1 of 2027. There was some other stuff in there that you can take a look at for this bill. I won't talk on it because I'm not an expert in the fire side of the house, but I just wanted you to be aware on the building code side, you can ask for direction and help from the state fire marshal's office, and they can give a binding decision. So SB 494, that one updated the code requirements from the 2021 NFPA to the 2024, and the NFPA 1 from 2021 to 2024. It also clarifies a few other things, and reporting incidences is a great thing to refer to your fire guys, and especially your fire volunteer. This took effect on July 27th of last month. So just be aware this is in effect, and reporting requirements have been updated as well. So if you have an incident in your town, there are some additional reporting requirements. Again, I'm not an expert. If you need clarifying information, I would certainly reach out to the State Fire Marshal's office. Three honorable mentions. I'll make these quick. That will probably come up again this coming year. HB 1004. This was an effort to exempt up to 4 dwelling units or 4 residential units, similar to 1 and 2 families that don't require sprinkler system. This would have allowed for up to 4 dwelling units to be without sprinkler system. So it could be designed and constructed without sprinkler system. This was put into this ITL, the interim study committee. There's some groups that are looking at this to maybe bring it back. 1652 relative to permitting and third party. This is going to be a big one. I mention it again because 188 really opened up an opportunity for communities to take advantage of professionals that help the system move along while still retaining the authority of municipalities to enforce and regulate and have the building permit process in their community. However, some of these efforts, they're trying to expand these. One thing was last year they tried to say any home improvement under $100,000 has to be instantly permitted at the day of application and can be third-party inspected. So we're going to see more and more of that. One of the other things was relative to solar permitting, which was also a third party. It was an attachment, but a different bill under the old 188 section for third-party inspection and plan review. So instant solar permitting, we worked with the sponsors of this bill, Keene specifically, to work on how this would work for municipalities and if it could work for municipalities. We've been able to, and hopefully starting tomorrow, we'll be able to start instantly issuing permits with Solar App Plus. They review all of the code requirements, zoning requirements, floodplain requirements as part of the plan review process and provide us with an approval number. That approval number goes into our system and the permit gets instantly issued. So they could apply for this with a Solar App approved number. It could be issued within as soon as they apply for it. They have to send all their information to Solar App Plus and they review that. So it's a really good way of speeding up not only the permitting process, but also getting the solar and solar systems out there. So I think I have one last slide. Takeaways. There was a really big push to speed up permitting processes and the way that communities or municipalities do business. I think we struck a balance on a lot of these bills to not strip away or push things too quickly. It's still, a lot of these bills still retain all the requirements for leading up to that building permit process. So zoning, planning board, all that kind of stuff. A lot of these wanted to skip a lot of that and just go straight to building. So really, I want to say that we worked really hard to get good bills, or as best we could, to still make them manageable without putting undue stress. So, but they did a great job. They were very willing to work with communities and a lot of the groups to hear and have input on them. But it does move a lot of these. It does change the way we do business as a state of New Hampshire for building permit process over the last 25 years. So I will leave it at that. This is our contact information if you have anything, and I'll turn it back over to Noah with 2 minutes left. Sorry.
You are fine. Thank you so much, Mike, and thanks, folks, for sticking with us. As Mike said, here's our contact information. We do have a couple minutes for questions. I'm going to go back. There are a couple questions that were in the chat. Definitely feel free to follow up with either Mike or I. You can also always email planning@livefree.nh.gov. And then I also want to note that the slides are now posted in the chat, or are now available online. So I'm going to just put the link in the chat, and we will make sure to email out the slides as well to everybody. But I did just want to make sure we got to a couple of the other questions in the chat. And folks, feel free to also, if you have additional questions right now, you can put them in the chat now as well. So the first question was, I think I answered most of them, but there's a couple more questions on childcare. So Mary asked, aren't home-based childcare facilities required to be allowed in residential districts up to 12 spots? And so I did say, yeah. So I did respond to that. So family and group family childcare as defined in RSA 170E 2, Roman numeral 4. So definitions for A and B as family daycare and family group daycare. So it's together is up to 12 children. So that is what you have to allow in residential districts as of right. That's different from standalone child care centers outside of the home, which there's a number of different definitions for different types of center-based programs in that same section, in section 170E2, Roman numeral IV, in letters C through G and I. And those do not have, those are larger standalone centers, do not have to be allowed in residential districts. Those only have to be allowed in commercial zoning districts. The answer, the ZBA continuing service, the appeals board. Okay. Then there was a question about, can you clarify again the sewer regulations for House Bill 1010? Would a builder be able to install their own septic system for a multifamily development on commercial land? And so if you look in the definition of public sewer, in the definition of sewage infrastructure in RSA 147:8, which is referenced in 67480. Public sewer is specifically defined in 147:8 as any sewer constructed and maintained by taxation or any sewer which is open for general use upon the payment of a rental license or other fee. So a septic system built by the builder would not qualify as sewage infrastructure under 67480. And so as I said during when we were talking about 1010, if you do not have public sewer available and the municipality has no intent of building public sewer, House Bill 1010 and House Bill 1588 really don't apply, because you'll never be able to developer will never be able to won't be able to pass the adequate infrastructure test, and you don't pass the adequate infrastructure test, you don't have to permit multifamily housing in those commercial districts. Excuse me, in those commercial districts. Yes. All right, I've seen one or two more questions popping in here. With limited site plan review in commercial districts, can town enforce policies such as signing and lighting? So let me differentiate. So you can still do site plan review, including for things like lighting and signage for multifamily developments. There's no question. You cannot do site plan review for these child care centers with a licensed capacity of less than 30 children for House Bill 1195. Can towns enforce policies such as signage and lighting? The legislative intent of House Bill 1195 is to allow as of right and to not allow site plan review for license capacity under 30 children. So but there is not a stipulation on the child care center law that you can't impose other regulations like there is for the multifamily commercial district law in 1588. So I'm not going to give a legal opinion here. I think you could certainly try to add a signage or lighting requirement for centers in your commercial district if they apply to other commercial developments. We'll have to see. I think this is one that maybe the courts may have to decide, may have to rule on. Okay. Then last question, on SB 564, for a town like Jaffrey that already has an open space development ordinance identifying conservation areas and regulating where utilities may be located, should we be planning an ordinance amendment before April 1st, 2027? And how should municipalities handle the apparent conflict between the statute's treatment of conservation areas and open space areas? Great question. So the April 1st effective date on 564 is the intent to be able to do zoning amendments, bring zoning amendments to town meeting, with the understanding that most towns have town meeting in March. Yes, there's a couple towns that have town meeting in April and May. How should you handle the apparent conflict between the statute's treatment of conservation areas and open space areas? So like I said, I would, if you were concerned about or want to protect municipal authority to regulate utilities in those open space conservation areas, I would review your ordinance and see if you currently refer to open space areas for subdivisions or for lots. I would change those references to conservation areas, as long as, obviously, if you have a definition of open space area that differs from the definition of conservation area, you might have to rectify those two definitions. But generally speaking, I would recommend putting forward a zoning amendment to strike or replace any reference to open space areas, references to conservation areas, to avail yourselves, if the municipality wants to avail itself of that authority, to at least regulate by a conditional use permit or special exception for utilities in those open space areas. Hopefully that's helpful. I realize we could probably go on and on with more questions for another hour. I want to thank all the folks that have stuck with us today. Again, feel free to reach out to Mike and I. My office, the Office of Planning and Development, will be issuing more written guidance later this fall. I don't have an exact date for that yet. I'm sure we'll be doing this webinar in other formats. And we'll also be sending out the slides and a recording of today's webinar as well. And please also fill out our webinar feedback survey. It's always great to hear how we can improve for the future. With that, I want to thank everybody and have a great afternoon. And thank Mike as well.